Greetings, members of THCtrust.org. This is just going to be a kind of a service announcement just to give you guys some expectations, things to know about THCtrust.org and myself, your trustee, and just so everyone can know what to expect, whether you're a premium member of our website, one of the supporting members, whether you've ever made a donation for the master file, which is what you're looking at on the screen right here, or whether you're just a member of the organization. So we used to do the membership where we offered membership for $24 a month, and the membership pretty much included our research and templates and pretty much priority placement when it comes to answering questions, responding to emails, and even taking telephone calls. That's kind of what premium membership regarded. Some people came to the website because they were just learning how to fix their own credit, right? We don't fix credit for people or anything like that. Sometimes I direct you out to other people that I know that can assist with those services. But for the most part, what I'm trying to explain is some people come to the website, to the organization, to research all kind of different things, to learn different things. Some people were only interested in fixing credit, and then they learned things about a secured party creditor, or they learned things about a trust. So some people were just dealing with the mortgage and wanted some direction in that area with our level of research, and wasn't so much interested in things like fixing credit or operating in trust. So that's kind of how premium membership, there's a lot of little tricks of the trade and things that can be learned, and things that I've discussed, other people discussed in videos. Our personal templates have been available to members of the premium membership, with the exception of the master file, which specifically deals with status correction and secured party creditor and things. Now, as of recently, I've made, just not as a obligation, just because it's something I decided to do. Many of you guys have already noticed it. I made the master file and the master file available for premium members of the organization. I just made it available. However, that can be ended, because that's not like part of the service. I never offered that as part of the premium membership. It's just something that I'm doing. Now, but for those who've made the $150 donation, when it was available at that time, as I've always said, you're going to have indefinite access to the master file, because you really invested in the research, because I thought this was thing was going to be created in about 3 months, and I think we're going on like 1.5 years, and I'm still working on it. You know what I'm saying? So, well, it's actually for the most part complete, but we're going to be continuously fine-tuning it. Now, there's going to be some changes coming to THCtrust.org. So maybe after this video, I don't know when, I may take down any opportunity to subscribe as a donating member. And the reason is because the administration of the website is becoming too much of a burden on myself. And I've actually hired people 2 occasions to put in a payment processor that can handle the membership. You know what I'm saying? So like when somebody's subscribing, it automatically updates their permissions, and I don't have to manually go in there and make sure they're in the premium membership group. And the software, I can't seem to get it to work correctly. I don't really have a lot of time to invest in figuring it out, because I'm doing the research. And then I've been hiring people, and the matter has just not got better. I'm just ended up spending money, and I can't resolve this situation right now. The situation is the membership thing. So what I'm going to end up doing, moving into the future, in the near future, just as soon as I can organize it and arrange it, is that I'm probably going to have just one yearly donation that you make for membership on a yearly basis, And that donation is going to include access to everything, including the master file. And it's going to run for 1 year. Now, everyone who's already a member at this time or has already donated for the master file, you're going to be all good. So you don't have to worry about anything. We'll figure out how we're going to do that. But I just have to do that because I spend too much time trying to correct membership issues in a site, sending erroneous emails and things that shouldn't go. So in the background, I'm structuring things though. I'm structuring things. So rock with me here. Things is going to get better. And so there's going to be 2 major changes coming. One is that membership is going to be a one-time donation. Maybe we'll do it biannually. Maybe we'll add 6 months, but pretty much it's not going to be a monthly reoccurring thing. So then expect the membership to be, I want to say, am I just going to I'm not going to randomly throw a number, but let me think for a second. It's going to include the master file and all the templates to everything. And it's going to include telephone support for things that are brief and to the point. That means you have a specific question. And you're not calling me to just teach you a subject. You understand what I'm saying? You research the subject, but there's just the one thing that you don't understand. Can somebody help you maybe better understand this specific point? It's quick to the point, so I could be like, yeah, I understand what you're asking. And then I could give you an answer or tell you straight up, sorry, I don't know. Right? And it may not be me. It may be another brother. And I say another brother because I didn't get into everything I want to discuss. But another reason why I'm restructuring things is because here's the situation right now. And as just one person, see, a lot of people, please understand this too. A lot of people think that I'm a whole lot of people over here. And I appreciate that because that lets me know that I am actually doing a lot of things. But now I have to structure things better so more services can get done. There's a shortage every time someone asks me about something, and you're probably a witness listening to this. I always have to say I can't really entertain that right now because I'm focused on status correction and UCC. I can't really entertain that, and that's been a continuous answer. So I've known it was necessary, but now it's to the point that I have to take these resources and I have to expand the operation of the organization so that we can provide more services and we can begin to build out staff to help and assist with these specific areas. Greetings. So once again here on the screen you're looking at the master file. The majority of what you need to be concerned with is simply it's one page. And what is this whole one page about? Well, you have to start from the top and then you go all the way down here. So that means you kind of start up here when you're working through it and you work your way kind of downwards. However, you start with these videos. You can look at this video right here. I do a video about the executor letter. Then you can start with these videos. So these are your first 3 videos that you really watch. And they're going to demonstrate, they're going to talk about the master file. But you have to understand that some of them are older videos, so you have to take the information, but understand that the master file has been reorganized a little bit. And then down here, these are other videos that you should also watch. So there's more than enough videos to watch. There's a lot of references down here. There's at least 10 references. And I'm going to provide more references here too. So these are just things that you can watch and get to learn. And then you can Google, you can look at YouTube, and you can watch other information about secured party creditor. There's some other things down here. These things, as you see, I say don't worry about this stuff. I will get to it. It's nothing for you to really worry about, but maybe you just want to click on it and maybe you want to use these things in a different type of way. For example, my copyright has made it, well, I did the copyright. You may want to put the copyright in this national filing. Nonetheless, you could probably guess that in the future, I'm going to talk more about these specific documents, where one might use them. But this up here represents the basic secured party creditor filing. This is not to say this is the only way it can be done, but this is the way that we've perfected it with a solid foundation based off of the things we found were most critical. And we'll continue to update this, but I just kind of want to get an understanding of this is how it's kind of set up here. Now, one more thing. Let me let this helicopter file. Okay, so the next thing is, so all of this stuff is preparing you for what? A UCC filing. The UCC filing, this would be a demonstration of the UCC filing right here. And of course, when you click this, up comes, don't worry about this form at the top. These forms are here for a reason. We're going to get to those, but we're not here yet. The reason is because simultaneously, or actually probably before you file the UCC, or maybe right after, simultaneously at the real time, your secured party is a trust. A trust is who holds the estate. So for example, when you scroll down here on your UCC-1 form and you look at this box 1 right here, what do you see in box 1? This is actually what it says. Doe L. John Alex, trustee, under declaration of trust, dated 5/1879. This is known as a trust registration statement. This is an example of a grantor's revocable trust. Some people call that a living trust, because as long as the grantor, if the grantor is also the trustee, and he has title and right to control the property, and he also retains rights to revoke the property, he retains those rights obviously for his lifetime, the life of the trust. But anyways, let's put it like this: any living trust is revocable during the life of the grantor. So this is a revocable trust, and a revocable trust that's expressed by the trustee is always under declaration of trust. So this is why the proper secured party creditor, the only trust that I see that could properly be the first secured party creditor for the estate, is the trust that you express. Because although the estate, they're operating the estate in trust, you're only a surety. You're not necessarily the trustee, or you become a trustee in default. But when you express the trust, that makes you a secured party. And you could look under Article 9, although this particular secured party filing isn't really about Article 9, but you can look under Article 9 and it'll tell you that a trustee of a trust is a secured party, or they say a trust is a secured party, something like that. But you can go look that up. We're more or less dealing with we're dealing with the more of a security entitlement, initial registration of a security interest. So that might be more of an Article 8 filing. And this filing is pretty much on our document of title over the estate. And the document of title is kind of like Article 7. So this is more like Article 7, Article 8 filing. There's some elements of Article 9 because Article 9 talks about non-UCC filings. Some non-UCC filings are Article 8 nature. So you got to go read those articles too. We're just kind of going through the technical part of this real quick. Maybe in the next video after this, we'll go into some further research analysis. We're just looking at the forms here. So notice the reason why I brought this out is because when we came up here, you realize that there's a SS4 form. What is the legal name of the entity? Doe L. John Alex, trustee, under declaration of trust, dated whatever. Obviously, this date doesn't match up with the date we just seen on the UCC-1, but in reality, it would. You know what I'm saying? When I get time in the background, that's when I go through and I be updating and correcting the forms so people don't get confused. But at the same time, this is why you have to demonstrate a little bit of competency. Research and watching these videos will let you know that this secured party down here is a trust. And the SS4 form is the application for an employee identification number. Because every time you get a trust, you want to apply for a tax ID number. And then you want to do some other forms such as a W8 BEN, an 8832, entity classification, or other different things to identify or to further express the status, the accounting, the relationship, with the treatment of that trust with the IRS. So notice, we're talking about the UCC filing here, and We see that the secured party has to be a trust, as we see on the form, on the UCC down here. We see the secured party has to be a trust. And then we know that a trust is an entity. So then we have to do a power of attorney and some other IRS forms to appropriately set that entity up. Right? So back to what I was showing you here, you have, but even before we got to the recording of the UCC-1, we had to go through this information up here. And what is this information up here for the most part going to do? Most of this information up here is dealing with the estate, the birth certificate or the certificate of live birth, which is the identifying instrument for the estate, and then it deals with recording title over the estate in the county. You know, that being an initial registration or registration of title. The way that you demonstrate title under common law is by affidavit of title, or you know, affidavit of title, which is a document of title, which is a certificate of title, which and of course the affidavit of title on a certificate of live birth, or what some people was calling the Rule 220 affidavit, what we've called the Rule 220 affidavit. That's what most of this deals with, putting a title over the instrument that evidences the estate and getting a record of that in the county. And after the perfection, because how do you perfect your lawful rights under the common law? By a recording and a public act of the recording, right? That becomes unrebutted and remains in a record for, I want to say, 90 days, and then that becomes cured. So that part is all done first. So then, so now here's another thing. Once again, obviously, this is just oversight. I talked about the affidavit of title, but even in the affidavit of title, for example, let's click it. Example, the affidavit of title. But let me scroll down. Okay, I took it out of this one. No, I didn't. Witnesseth, by virtue of the power vested in me, through this deed I transfer and assign all right, title, and interest in the lands, tenements, hereditaments, in Hamilton County, or wheresoever situated, to vest in Doe John Alex, trustee, under declaration of trust, dated, whatever. So what I was going to demonstrate is this affidavit of title is also what? A trust instrument, or a deed, which once again is why we want to record this in the county. So you have the affidavit of title, or if it didn't turn out to be the affidavit of title, you may do a certificate of title. Some of this is going to depend, you're going to have to be reading. It's going to be an affidavit of title, certificate of title, memorandum of trust, affidavit of successor trustee, whatever type of conveyance instrument that's allowable to record in your county to demonstrate your right to own or title property. That's what you're going to have to do to demonstrate title under common law by getting a county recording of title on a certificate of live birth. So preferably that's what the affidavit is, but the thing is, it's always going to be in the form of a deed. It's going to be a conveyance. An affidavit is a deed. So there's going to be a grantor and the necessity for there to be a grantee. You don't always have to call them grantor or grantee. For example, it can, it may just be common sense based off of reading the instrument. And this has to be done because of indexing. And the word indexing would be when they're actually doing the data entry of your record or your deed or your lien. Who the grantee is, who the grantor is, who the leasee is, who the leaseor is, or depending on however they're indexing it, who the trustor is, who the trustee is. So this is important. Now, all of these common law contracts, affidavit of title, deed of trust, memorandum of this, all these different type of transactions under the common law that can be recorded in the county are or may be construed as a form of a secure transaction. You just have to define what type of transaction it is. Most of the different types of transactions are talked about in various articles of the UCC, from Article 9 to Article 7 to Article 8. like the warehouse transactions, the Bailey, Baylor transactions. All of these are different type of transactions that result in a secured party. So people always get twisted and confused about the name secured party creditor. I used to ask people too, where have you found secured party creditor written? But, you know, to take it in context, what we're trying to just make sure everyone understands is what a secured party creditor is. On this particular form, whatever you put in box 3 is the secured party, right? The secured party, if you look down here, might be the leasee. It might be the co-signee. It might be the seller. It might be the Bailey. It might be the licensee, or it might be the licensor. You know, I didn't think far enough before I did this video to figure out in a transaction of the leasee or the leaseor who's the secured party. I think the secured party would actually be the leaseor. Yeah, because typically, but it all depends. You know, it all depends. But typically, in a typical general leasee-leaseor transaction, the leaseor, the one granting the lease, would be the secured party. The one receiving the lease would be the debtor. He would be the one under obligation. The same thing with the consignor. The consignor would be the grantor. The consignee receiving the consignment would be the debtor. The consignor would be the secured party. In this particular case, what are we looking at? We're looking at the grantor trustee, or the grantor beneficiary. It's the living trust, right? So the grantor, as I said, would be the secured party. Who's the grantor, right? Doe L. John Alex trustee under declaration of trust. That's the trust that was registered in the very beginning. The trust that was registered over the estate, the estate with the estate filing number. This is the trust registered on the birth certificate, so that's the grantor. The name of the estate is the John Alex Doe. What was box 1A? That's the Sesticate Trust. That's the name of the estate that's secured by the debtor, is secured by the secured party. What is the property? Well, this is the debtor. Here's the property of the debtor. You got the UCC search results. These IRS forms, I've always said, technically don't have to be in here. They're not really the property of the debtor. But the reason why I thought about putting them in here at this time is because, you know, obviously these would be copies of the IRS forms that were already submitted, probably with the registered or certified mail strip on them, showing that they already were delivered to wherever they needed to go. So, but it's just so that I can have the record of the trust's holding in one place should I have to demonstrate. That's why I put them in here as enclosures. But realistically, they don't have to be in here. They're kind of outside of this transaction. The UCC search results would be in there. Affidavit of title would be in there. Or your memorandum of trust with the attached Schedule A, which is all these things are going to be a certificate. Or the affidavit of title with the attached signature birth certificate. The memorandum of trust with the attached Schedule A. That Schedule A would be the certificate, which would be the property or the estate. You see, so that's anyway. Those, I just wanted to point out some things about that, and then of course, obviously, as you don't see here, your memorandum of trust would be behind that, just as we stated, and or an affidavit of title would be behind there, just as we stated. But most importantly, whichever of these title documents you use, memorandum of trust or affidavit of title, or a memorandum of trust with the affidavit of title attached to the certificate as property, or certificate of trust, or whatever is necessary to get that county recording, you really want the certificate of live birth or a copy of it behind it. And there you have it. So anyway, that is what we endeavor to do here to file the UCC-1, right? But why do then, if we just looked at that and you've seen the IRS forms and you've seen the demonstration that I just briefly walked through with the UCC, then what is the importance of going all of this? Well, I'll tell you why. Something very important when it comes to UCC filings. So let's look at this one more time here. One of the things is the secure, let's pay closer attention to this line one more time. The secured party. Doe L. John, Alex trustee under declaration of trust, dated whatever. Why is the secured party a trust? Well, many people have learned when you use all capital names as a secured party, they tend to reject the filing. When you do all capital names. And the reason is because these are for businesses, right? Organizations. Now, and they're not for names. So, this is important also because, remember, in the beginning they set up an estate. The estate, from my research, is the parcel number or the state filing number on a certificate of live birth. I just call it a parcel number. That's the estate number. The estate does not do business. Businesses are conducted on estates, or business actually is conducted on the estate. They're developing the one estate. And then there's parcel numbers. And so your parcel, you may just say this is your estate, or the John Alex Doe estate of the entire estate that they're developing. Now, I believe when we say what entire estate are they developing, I think and I believe that this goes into the treaties, even the treaties with the Kingdom of Morocco, which is a developing nation. So then it goes into these treaties of commerce and taxation and all of these different things, which is construction, because they're doing construction on the bonds, on the people, and they're doing it under developing the nation, I'm sure. So I'm pretty sure that that's how that flies in. So we know that the birth certificate is dealing with the estate, and everything after that is the administration of the estate through various government trusts, constructive trusts, and even express trusts that are tied to this whole birth registration. Okay, so one thing that I've learned is that when you're coming in dealing with an estate, you have to have a clear chain of title. It's just like with the foreclosure thing. If you don't have clear chain of title, then your title is defective, right? So this estate was set up for a being, and the estate was either considered in some jurisdictions abandoned, maybe if you're looking at it from the admiralty military standpoint, so it came under occupation. And this is where so that's in one area. Other areas, you can say the estate or the occupant of the estate, if you want to say that you occupy the estate, is not competent, or the person is not considered competent. Maybe because they're not of the age of majority, or maybe because there's no evidence that they're of the age of majority, meaning that there's no record on the county. Maybe it's because they have no will. There's no, once again, a will demonstrates, the will is evidence of the mind, because you need the mind to direct your affairs. So that not having a mind, not having a will, but having a body and having feelings makes you incompetent. So that might be another reason why the Cesta K Trust continues to remain through departments of government and government agencies doing construction on the Cesta K Trust. This is agency law. This is the law of agency, and this is what all of the military executive law is set up for. All of that admiralty type stuff, it is set up to control the property, basically. So everything is military when they talk about administering the agency. Look at the Social Security Administration, the Postal Service, and all these things. These are military setup organizations. I'm saying all this so that you'll better understand when we get further into talking about correcting the status, why we've taken the specific route that we've taken. But I was mentioning agency law because that's how they're operating. They're doing functions of government as extensions or as agents of your John Alex Doe or of the John Alex Doe estate. So these are agency relationships. Now, when you hear agency, you think of government agency. What do government agencies do? They pretty much execute executorial powers. They exercise things from the executive branch of government. So it's the executive function that's missing when we talk about, well, that's one of the things that's missing in regard to administering the estate, evidence of the executorship. Because why? Because the executor is an executor general. Executor general, postmaster general, attorney general, inspector general. These are the highest offices in the military, and it's showing you that there's obviously something military going on here. And so when you deal with estates under military occupation, an executor is a general executor, executor general. Once again, you see how the lack of having your estate set up leaves your estate to be administered. And here's how we know. Because there's the estate number, and then there's the Cestui Trust, or the John Alex Doe Trust, sitting on top of the estate. Then through the postal system, every time we communicate with the John Alex Doe, we tend to put zip codes after it to traverse him through various federal jurisdictions that only end up back in Washington, D.C. with that contract saying that it's under administration, once again, under the federal executive branch administration and everything else. And once again, this whole occupation federal administration is all dependent upon who owns the property, evidence of the trust. So the first thing we do to correct status is we express the trust that titles the estate. That's under the trust law. The appointment of the executor, which is kind of like the military merit, that's more under the estate occupation type of stuff. So both of these things are slightly different. But in common sense, when you're dealing with an estate, especially a living estate, because the estate is both living and dead. It's maybe neither of the two. But when you're dealing with the estate, the business of an estate is relative. It's kind of like a trust. An executor is a fiduciary, and that's separate than, that's a separate realm or jurisdiction than being the trustee handling the business for the property of the trust, which is basically the estate. However, you being the only living man, the only being who can really facilitate action, you traverse jurisdictions. Your pen has no limit. You're limitless. So I'm basically saying you're using the same energy as the executor for the estate, right? Which is, you know, a slight difference from the trust jurisdiction, where you're the trustee doing the administration for the living estate or the living trust. Same entity, but you just have to be able to make the separation, right? Because when you understand what's going on, then you will better know how to navigate and what's going on. So, but once again, a trustee and an agent are not the same. And accordingly, as an operation of law, where there's a clear express trust, there's no agency relationship. The two laws do not simultaneously operate at the same time. So there's many things, there's probably a billion things that can be said, and many things, you know, just technicalities of why when you show up operating the John Alex Doe Trust, the John Alex Doe agency must terminate in real time in that same playing field, right? So in order to operate the John Alex Doe Trust, you have to express, excuse me, sorry, I spilled something. You have to express the trust. But anyways, let me kind of jump back on the point here. So this represents the estate, or the Cestui Trust. The Cestui Trust governing that parcel being the part of the estate, the overall estate, which I believe is the United States of North America, which is presently under treaties, several treaties that have been auto-renewed for construction. probably renewed by the people who it benefited, but actually, I believe they're, we're the true beneficiaries of these treaties. This is why we're getting the knowledge right now to know how to use these tools, to know what the whole tie-in is, how does all this stuff tie into the straw man. So there's a trust expressed, and the trust ties directly into the certificate, because this date right here is, I don't like to use the quote-unquote birth date. I use the date that the trust was registered, because the date that the estate was received in trust, the date that the county recorder, which is an executive officer, I believe, is that right? I've seen it in some areas. I've seen them be executive officers. But either way, the day that they recorded that, the date that they received that, according to trust and equity law, that would be the date that the trust was established. So this syntax comes from the Treasury or the IRS, which is the syntax of identifying a trust. Look in the references and you'll see that trust registration statements, or in that document called Questions and Answers about Trust. So what we're doing is, this trust registration statement attaches directly to the certificate of live birth, because Doe L. John Alex, trustee, under declaration of trust, and then there's the date of the trust instrument, and then this right here, in the form of either an affidavit or a memorandum of trust, would be attached directly to the certificate being the trust instrument. So you're attaching right onto the face of the trust instrument, demonstrating title and ownership. That trust that you just expressed when you do that is what collapses this agency relationship in real time when someone's trying to govern your affairs. So that this original trust instrument, whether it's an affidavit of title, memorandum of trust, certification trust, on your original certificate, you must always keep that with you. These are now part of your important documents. Now when you go record something like a trust in the county, you always give them the original, because when you're doing county business, they're going to record and they're going to return the originals to you. Now when you're filing, they're going to keep whatever you give them as original, and they're going to give you a copy. So when you're filing documents on a state level, if your state is still walking things down and accepting filings, be prepared that they may keep the originals and give you copies back. Or they may keep the originals for the whole 90 days, for like 90 days, and then send the originals back. Maybe that has something to do with the curing process. But things are changing, so take that with a grain of salt. Maybe now filing and recording, they're still giving your originals back. But when you're recording, it's important that you give them original affidavits, you give them original certificates and things of the such. Let's see. So anyways, that's how we're directly connecting. We're directly putting a physical title on the estate and documentation. And then we're recording it to get a new docking number, which is, once again, all of this is on the admiralty side of things, right? So we're registering a claim on the admiralty side. For Moors, the L, Bay, Ali, Day, I believe is important. Usually we don't use these things in commerce, but actually we don't really have to worry about anyone using this name in commerce, because they are not going to want us to use a last name or a family name with an appellation, or a family name with a title L, Ali, Day, Bay. They're not going to want us. They're not going to want to accept that in commerce. So they're going to keep that on the outside, and they're just going to look and say, well, that's evidence of the title demonstration of who that person is. I hope that makes sense what I'm saying. But anyway, so that's really kind of the premise. That's where it starts. So you can kind of go through everything I said, and maybe the next time we will go in depth. So, but what I hope you got out of that is there's this estate. There's this underlying estate that's connected to everything else, which is estate. There's a grand estate. There's one estate. And then there's a parcel which identifies a particular division of that estate. The earth being the grand estate, Texas being a parcel of the grand estate, the body of the earth that has the same minerals, zinc, clay, whatever the body is made of is of earth, also becomes identified by a parcel number. That parcel number being the estate or the state number on the certificate of live birth, and the trust or the Cestui trust or the name with that went along with that registration. Because see, when they registered that property, that foundling, that found land or whatever they found, they registered it as estate with the estate number and the parcel number, and then they named the constructive trust that's gonna inherit or hold or title that property, and that became the quote-unquote infamous name, which is a Cestui trust or some type of entity, if you will. So we recognize that estate, and then we recognize that one of the ways that they hold that estate in abeyance, right? They hold it by way of military occupation because they say it's justified. That's where you can go into all that admiralty other stuff, but at the end of the day, it's justified through many different ways that you're incompetent, you haven't taken title of it, you're not at the age of majority, and all of these different dispositions that you got to correct. This is why we do, affidavits of title, memorandums of trust, and other different affidavits to correct those matters on the record. Once we correct those matters on the record, we get a docking ID and all of these things of how the title of the estate is now held in the trust, and then we go into the UCC filing to demonstrate that the trust is now the secured party for that debtor estate, and then we use these different IRS forms to structure the trust, who the trustee is, and once again, as you get into some of these other videos, you're going to recognize for Moors, proclaiming your nationality is important as a trustee, because no matter who you are as a trustee, no matter what your nationality is, your political status or standing is, the property held in trust, the idea is to keep the property as secure as possible. And a lot of contracts are enforced on the trustee based off of their civil and political status, their standing, whether they're citizens, whether they're nationals, their domicile. So all of these things are important. So for Moors, because the trustees at thttrust.org are Moors, although all the information isn't only applicable to Moors, when you get down to here, you're going to understand why correcting your status, your nationality, name corrections, and things are important, because they deal with who you are, your impersonum, I guess you will. Is that the word I'm looking for? But anyway, they deal with the status. They deal with your status as the person, as the trustee. Excuse me, as the trustee administering the trust. So that also, I'll just say it while I'm here too. We looked at that UCC-1. We looked at that trust in there, and we looked at the SS4 form to apply for a tax ID number for the trust that's managing the estate. This 98 series, apply for a tax ID number for Insider's Trust. That's different, right? That is just, I would say that's closer to the tax ID number that you want to use when you're dealing with your proper status. The one that's totally exempt for everything, maybe relating to other matters. So at the end of the day, when you finish structuring all this stuff, the clear title owner would be represented by a 98 series tax ID number, because he's tax exempt, or that entity is totally tax exempt, and it's not under any special rules, obligations, or regulations. It's the foreign sovereign trust, if you will. Let's see. Okay, so that being said, the first thing that you would do just to get where, so this could, what I'm about to say now, I could insert it before we talked about the UCC, before we briefly discussed the county filing, is the will and testament. Why the will and testament? Because remember, we said the first thing that they set up was this estate. They set up the estate by doing a parcel number, and the estate is for an inheritor, someone who's going to inherit this estate. But it was set up in such a way to keep you further ever disconnected from it for your life, right? And then for you to try to take control of it after you're dead, where there's really no control whatsoever. So the first thing we realize is, in order to express the title of property on an estate, the governing instrument is a will. So we created a will, and out of the will we appointed the executor, the general executor. the general executor, the office of the general executor, which is that highest military office, so that now we can make the directives and give the orders in regards to the estate, and our estate doesn't have to be considered abandoned. Plus, where do we get our authority? Well, where did the government get their authority? Through government, through the law of agency, through the law of constructive trusts is where they got their authority to administer the estate. We got our authority through the highest governing document as results to estates, and that's the will. The will directing the affairs of the testator of the estate. The will, his desire is for the life of and after the death of the person that all powers over the estate property be executed by the executor, and he appoints none other than the Doel John Alex as the executor for the estate. And then he appoints successor executors, and then he goes and records this will and testament so he can get a county deposit safekeeping number on his true copy of the will and testament that appoints the executor for the estate, for all proof, to be that probate and court document, and all proof that you are the executor, more higher than a testamentary letter, right? I kind of stumbled upon that because, you know, when you go record your will, right, you bring a certified copy, or you just bring a true copy of it, they're going to stamp your copy received with the safe, and they're going to give you all safekeeping information. So that's a very powerful document, whether you call it public record or private record. It allows one to show and prove in real time that they are the executor for the estate, and that really can't be challenged. And why? You know, so once you establish that you're the executor of the estate because you have evidence of your acknowledgement, acceptance, and you have proof of the last will and testament on deposit, right? This is why we do this will and testament as the first instrument here, right? Last will and testament. This is basic. Just the last will and testament of John Alex Doe. The same name as the estate, because that being the estate that they set up, and we're creating a will for that person or a will for that estate. We go to General Post Office. Why am I saying General Post Office? Because we're trying to keep it out of the district. When you start traversing zip codes, you're going into the district, you're going into administration, you're going into military occupation of the executive branch of government by way of the post office.